live on Facebook as well, so I'll just share the Facebook link with my colleague, or yeah, copy link. Oh, where is Little Neston? I don't know where Little Neston is. Thank you everyone for submitting your questions. I know the panelists, Henry and Olivia, have been preparing very good presentations based on what you asked, and it's really good to, well, good and bad that there are so many questions, but good that we're here to answer them and that we're here to clarify them. And we hope that you will leave this webinar with a lot more clarity about your rights in the UK and how you can exercise them, how you can prove that you have those rights. And also if you have anything, you can, if any of the questions are not covered, then you can ask more in the Q&A button down on the bottom of the screen. Oh, we've got a very good spread of guests today all over the country. I am in London. Where are you joining us from today, Olivia?
I'm in the Carpathian Mountains in Romania.
Nice. How long have you been there?
Just a couple of weeks. I came to get my passport renewed. Like a lot of the people who come to the Work Rights Centre, I did not want to get that one wrong. And I'll be back in London shortly this weekend.
Nice. What about you, Henry? Where are you joining us from?
Yeah, I'm joining from London. Yeah, South London.
Yeah,
hi, everybody.
London. Yeah. Cool. Okay, it's 5 past. Oh, there's a raised hand. Hands. I will wait for questions in the end of the webinar. As I said, like a lot of questions have been taken from the Zoom registration link, so it's quite likely that whatever question you have will be covered during the presentations today. But if not, leave your hand up, I'll come back later, or ask the question in the Q&A function here on Zoom. Okay, there's still a few people joining. I can see that the numbers of participants are going up and people are introducing themselves, but I'll just get started. So my name is Lara. I am the co-manager of the Young Europeans Network with Alexandra Bulat, who will appear in this call at some point today. The Young Europeans Network is the youth wing of the 3 Million, and the 3 Million, of course, has been around since 2016, campaigning for the rights of EU citizens in the UK, including campaigning for the removal of the fee for the EU settlement scheme application, and since then many other things, including campaigning for physical proof of our settled and pre-settled status now. And as the deadline for the applications have come and gone, the Young Europeans Network wanted to start presenting our followers and wider audience with new topics that we think everyone, all migrants and all British-born residents, should be aware of, including, of course, workers' rights. I called this session Life in the UK because one of the big campaigns of the Young Europeans Network is access to British citizenship. And to many of you who have started going through the process of applying to become British or are interested in that process, just like I am doing right now, you know that you get the little book called Life in the UK. And a lot of the questions and a lot of the comments there are not quite so relevant about what life in the UK really is like. That test is more of a memory test, in my view, and it misses out on informing residents of really important things, including how to protect your rights in the UK, if you suffer from any discrimination at the workplace, how you defend yourself from that, also including access to healthcare, access to benefits, pensions in the UK. Some of the questions in the forum talked about that as well. So we want to develop on those topics so that more of our followers receive that information and become fully aware of their rights. So I will stop talking now, well, in a bit. Basically, so just some admin. The chat where everyone's having lots of introductions, use that for exactly that. Talk about where you're from or what kind of issue, like if you relate to anything that the speakers are talking about, feel free to share your stories there. And my colleague Jay, who is having some posts there as well, he will be assisting with some important links and other issues that you can find more about. And then if you have actual questions about your own personal issues that you want to talk about, or a question that you think has not been answered by the panelists, you can use the Q&A function. So the two panelists will give a talk for about 15-20 minutes each. And then after the two of them have spoken, I will open for questions. And yeah, I will now see Alexandra is here now. She is my colleague that I talked about, but she will also be helping in the chat and with some other bits and bobs. So I will now, let me just say who the two speakers are. That's quite important. So we have Dr. Olivia from Work Rights Centre, which is a great partner of the 3 Million, helping us out a lot with informing EU citizens. A lot of you have probably been referred to them from us or have come to us from them and vice versa. And she will give more of a talk about how EU citizens' rights have changed or what is still the same and how you can prove your rights in the UK. And then we've got Henry Lopez from the International Workers of Great Britain Union, and he will give us an introduction to unions in the UK, how workers can defend their rights, and just basically an introduction of how you can start finding out more about how to get involved in union movement in the UK. So now I'll pass over to Dr. Olivia, please.
Fantastic. Thank you so much. It's really great to be here, and I completely share the enthusiasm for working with the 3 Million. This is the first time I have a chance to speak to the younger branch of the 3 Million, and I do feel a little bit like an imposter. I don't know if I make the age cut to be young, but it's really great to be here with you and to share the platform with Henry, who I must state again, I admire very much, and his union is fantastic. So I'm Olivia. I'm an anthropologist by training. I'm director of the Work Rights Centre. And what we do at the Work Rights Centre is really simple: employment rights. We're a charity founded in 2016 by migrants and for migrants. Most of my colleagues are from somewhere in the world. We focus very hard on frontline work, service provision, every day, Monday to Saturday. My colleagues in London and in Manchester work with people who haven't been paid by their bosses, who are discriminated against, or who simply want to understand their employment rights or want to accede to a better paid job. So we take that one-to-one, confidential, free advice work with people very seriously. But we also really enjoy presentations like this. I definitely do. We try to build, resilience where we can, and because we are all migrants and we've all been through this process of bordering and immigration checks and having to, account for our presence in the UK. This is something I care about very deeply as well. If you have a serious employment rights problem, please do get in touch with our team. We speak so many languages: Romanian, Bulgarian, Polish, Russian, Spanish, and Italian, and I'm sure they'll be happy to help. Now, today, I'm going to talk to you about 4 things. First, very briefly, I noticed some questions in the Zoom submissions about the EU settlement scheme generally, so I'm going to cover that briefly: who it's for and what does it do. Then in the second part, that's the media part, we're going to look at the new right to work checks. And as I'm going to show you in a minute, they really depend. The process depends on where in the EUSS application you are. In part 3, I'm going to do a little imagination exercise, think of a couple of problems that might arise and solutions, and then pass over to Henry before we take some questions. Okay. Briefly about the EU settlement scheme. This might be familiar to a lot of you, but there are a few dates that we're going to talk about over and over again, and I want you to understand why they are important. So it all starts with the Brexit referendum. I'm sure you know about it, but perhaps like me, you did not have a right to vote at the time, but now you are seeing the consequences. So in June 2016, the British public voted to leave the European Union. A few years and 2 prime ministers later, the government launched the EU settlement scheme to give EU nationals, EEA nationals, Swiss people, and their family members status after freedom of movement ended. As you know, it's a digital-only application based on residence in the UK during the period of free movement. Now, after many negotiations and much angst, the UK officially left the European Union on the 31st of January 2020. What happened at the time was that the government triggered 11 months of transition, during which the free movement of people, goods, and services was retained. Now, that transition ended on the 31st of December 2020. And this is the really significant date for us, 31st of December, because that's the last date of arrival to qualify for the EUSS. Everyone arriving from January on needed a visa, unless they're a family member of someone who has EUSS already. And we're going to talk about that in a minute. So important date number 1, December 2020. Important date number 2 was in June. Now, applications for the EUSS, as you know, officially closed on the 30th of June. Some late applications are accepted, but this is really important. The Home Office has discretion over the applications it will consider. The other thing that's extremely significant about the 30th of June is that this is the moment when a whole new series of immigration checks begin, and you will likely encounter them at your workplace, in your relationship with your education provider, if you go to university or college in the UK, and also in some interactions with landlords. Now, very briefly, just in relation to some of the questions submitted in Zoom, and also acknowledging the fact that many of you here will have EUSS status, but perhaps you have friends or family or partners who still want to apply. I'd like to address this one question. If the deadline was on the 30th of June, who can still apply? There are basically two main categories. On the one hand, we have EEA nationals. EEA plus basically refers to the whole category of eligible EU, Swiss, and EEA. So EEA plus nationals who can demonstrate what the Home Office calls reasonable grounds. So the Home Office stated that it will be flexible with applications submitted by people who are children and through no fault of their own, their parents didn't apply, people who are digitally illiterate, or who are victims of abuse, modern day slavery, and other such circumstances. Applicants will of course need a valid ID and proof of residence in the UK before freedom of movement ended, as well as a cover letter explaining why the application was delayed. And this is where it gets a little tricky. If you'd like help with this type of late application, please do get in touch with the Work Rights Centre. We're happy to do it. Now, the second category of people who are eligible to still apply refers to family members. Now, eligible family members include spouses or partners. They don't have to be married. A long-term relationship matters as well. Children or grandchildren under 21, or children or grandchildren who are older than 21, but who are dependent upon the EEA national. Same applies for parents and grandparents. If you can demonstrate a relationship of dependency, then that gives them grounds to apply to the EUSS as a family member. And they too will have to include 3 different types of evidence. On the one hand, evidence about themselves, such as ID, evidence about that EEA national who's their family member and who has to have EUSS already and has to prove residence before freedom of movement ended on the 31st of December. And also, they really need to prove evidence about the relationship. They need to show that the relationship started before freedom of movement ended. So this might mean something like a marriage certificate or a birth certificate, or if you're thinking of bringing your partner, long-term partner, and you're not married yet, something like a rental agreement that shows that you are living together, or bank statements that show that you are in a long-term relationship. It's a tricky thing to have to evidence. It's not exactly romantic, but this is how it works. And you can learn more about the process on the government website. Now, very briefly, what you need to know about the format is that it's digital. You can learn a lot about it on the government website and on our website. I won't talk too much about it. The only thing to know is that it has two parts. There's an application that happens online on the government's website, and there's another identity checking process that happens via mobile app. Now, this is where it gets really interesting and it starts mattering in terms of rights. So at the moment, there's a single application for the EU settlement scheme, but the status varies. So according to the latest statistics from the Home Office, on the 30th of June, which was the day of the deadline, there were over 6 million applications, but only 5,400,000 concluded. So I'll let you do the maths. So basically, if you subtract the concluded applications from the applications that were actually submitted, you can tell that more than 500,000 people, well, 500,000 applications have not been decided yet. So all of these people are still waiting for an outcome. Their status is effectively pending. And as we'll learn in a minute, this really matters for their employment rights. Now, if they're among the 5 million lucky ones, they may have received either settled status, which is effectively indefinite leave to remain, awarded to those who could prove 5 years of continuous residence in the UK. Some people asked on the chat when you can apply for settled status, basically if you have these 5 years of continuous residence. Alternatively, even if you just have 1 day of residence in the UK on the 31st of December 2020, you basically get something called pre-settled status. It's a limited leave to remain. And what's crucial about this is that it expires, and you have to make sure that you apply to upgrade your status before it expires. And as I mentioned earlier, we also have the almost more than 500,000 applications yet to receive an outcome, and all those people who have not applied as well. We can't know, unfortunately, how many they are, but it's very significant. If you haven't applied yet, please do. Now, we worked on this table very hard because we get so many questions about rights, and the rights you have really depend on your status. So on the left-hand column, if you can look at your screens, we have various types of rights in the UK: to work, to rent, to claim welfare or healthcare. On the right-hand columns, we have a type of EUSS status. So first, if you have pre-settled status, you can tell by the green ticks, you pretty much get everything. The only difficulty there is if you have pre-settled status and you're trying to apply for welfare. This is where things get a little more complicated. You should not be rejected by default, but technically, if you don't have another qualifying right to reside, in other words, if you don't have a history of employment, or if you're not in work, as well as having pre-settled status, it's much harder to claim welfare. Now, it's really important to note, and if there's one thing that you remember from my presentation today, please let it be this. You also have rights if you've applied to the EUSS and your application is pending. Please don't let anyone tell you that unless you have an outcome, you don't have rights. You do. The only scenario in which you're really in trouble is if you've missed the deadline, okay? That's where you can tell by the red crosses, you really lose a whole bunch of rights. And now I'm going to focus more closely on the process for right to work checks. Technically, all of us who took up a job at some point were subjected to a right to work check. Until the 30th of June, we could pass it just by demonstrating nationality with an ID or a passport. From the 30th of June, the process becomes a little more complicated. Now, I would like you to think like an employer and understand the rules they have to abide by in terms of immigration, but also in terms of equality. So employers technically have a duty to check the right to work for anyone who's under a contract of employment, service, or apprenticeship, whether this was expressed in writing or whether it was just a verbal agreement. They really have that duty. But they also have a duty to not discriminate. So they can't simply check the status of people who appear to be migrants because they have an accent or because of the way they look. If they do that, they could be breaking the law. And I'm taking these word by word from the Home Office Guide to Employers. If there's a second thing you remember from the presentation, is that employers really have to balance these two duties towards the Home Office on the one hand and towards the Equalities Act on the other. But this is where it gets a little bit complicated. The Home Office tells employers that they don't have to conduct retrospective checks for staff they hired before the 30th of June. But it doesn't tell them that they can't or that they shouldn't conduct these checks. So you may find yourself in a scenario where you've been working for the same employer for years, and suddenly today they tell you, oh, can you please show me that you have a right to work in the country? It's offensive, but it can be discriminatory, but it can happen. And if you think it's discriminatory, basically ask yourself this. If you're being intercepted, if it's only applied to yourself or to some employees, because of a protected characteristic under the Equalities Act, for example, because of your nationality or because of your color or your race or your accent, then yes, you might have a case for discrimination. But if the employer actually asks everybody, including British workers, including all contractors, to prove the right to work for reasons unrelated to a protected characteristic. So, for example, someone might say, all of our HR data got deleted, then you may not have a case after all. So as I mentioned earlier, the process for proving a right to work and the process for employers to check it has three phases depending on your status. And we're going to look at them one by one. First, if you have your status obtained, in summary, you prove it via share code. In the second scenario, if your status is pending, you're one of the 500,000 whose applications is still being decided, your employer has a different process and it's called the Employer Checking Service. It's a completely separate website. In the third scenario, if you haven't applied at all and if you don't have another immigration status, then you may not have a right to work. And we'll talk about this in a minute. Okay, for the simple scenario, I've prepared two resources for you today. I'm going to kindly ask that you watch one of them at home. This video right here shows you how to issue a share code. Someone asked if there's a fee for that. No, there isn't. Please don't let anyone tell you otherwise. Issuing a share code is just something that happens online and you can do it on your own. This video shows you exactly step by step how to do it. Now, the second thing I prepared, and this is what I'm going to ask us to watch, it's only 2 minutes, it basically shows you what employers see when they ask for your share code. So let's take 2 minutes to just view this because it explains it in a very concise, step-by-step manner. And digital processes are often easier to illustrate than to explain.
Because of Brexit, hiring people with status under the EU settlement scheme will require a new right to work check. This is a guide on how to do it with respect for the law and for staff. As an employer, the first thing to remember is that the EU settlement scheme applies to a whole range of people. This includes EU citizens with IDs issued by an EU country, but also their family members, whose passports may be issued by a country anywhere in the world. Here's how you conduct the right to work checks. Open a web browser and look up Check Right to Work. From the government page, choose the option to check the applicant's right to work online. Then it's a simple step-by-step process. First, enter the applicant's share code. We've explained how they can generate it in a different video. Then enter their date of birth. You will see a confirmation of their name and right to work. Check that the picture matches the applicant, then file a copy of the online confirmation and store it safely. You will need it for the duration of their employment and 2 years later. It's important to remember that some people may not have received a decision on their EUSS application yet at the time that they apply for a job. This does not mean that they don't have a right to work, and you can still check it by using the employer checking service. Before you start, you'll need their date of birth, nationality, and Home Office reference number, which can be found in their certificate of application.
All right.
When it comes to immigration,
we're going to look at the second scenario if your application is pending in a second. But I want you to remember that shot with the employer who logs in using your share code and your date of birth and what they see. So see a picture of your face, which will probably never look as good as that picture. That's a computer-generated image, by the way. It's not a real person. So see a picture of your face. They'll see exactly what status you have and when it expires. Now, scenario number 2, proving a right to work without a share code. Again, I'm quoting directly from the Home Office Guide to Employers. And the reason I'm doing this is because there's a lot of misinformation out there about this process. So technically, EEA citizens and family members who've made a valid application to the EU settlement scheme can continue to live their life in the UK and maintain the right to work until their application is determined. So don't let anyone tell you otherwise. And the employers have to provide prospective employees with every opportunity to prove the right to work and should not discriminate against those with an outstanding valid application. I keep emphasizing this because at the Work Rights Centre, we've heard from a lot of people since the 30th of June who've been asked to take time off from work unpaid, or who've just been dismissed, unfairly dismissed, because of issues over this. All of them had applied to the EUSS, but their applications were stuck in a backlog. The employer simply did not understand and was not open to communicating either. But there is a process. So please fight back if someone tells you, oh, you don't have a share code, you don't have a right to work. Actually, you do. And the process is the following. The evidence you show your employer really depends on how you applied. If you made a paper application, you probably received a letter or an email notification acknowledging receipt of your application. You basically, you have to show that to the employer, and the employer has to request a right to work check from the employer checking service. That's just the website. If you made your application online, you may have received something called a digital certificate of application, in which case, if your application was made before the 30th of June, in theory, there are digital certificates of application that actually enable you to issue a share code. If that's the case, your employer can just use the share code, as in the video I've shown you, and they don't need to use the separate service. But if you've made your application late, for whatever reason, show your certificate of application to the employer, and they'll have to use the employer checking service. Similarly, if you received any other proof of your application, that's not a share code, again, the employer will have to use the employer checking service. Now, scenario number 3 is the really problematic one. Do you have a right to work without an EUSS application? And there's 2 ways to answer this. If you already started work before the 30th of June, when the deadline happened, you might, but this really depends on your employer's decision. This again is a quote from the Home Office Guide to Employers. Effectively, it gives employers the option to keep people on their records and to incentivize them to apply, but it also gives them the option to do otherwise. So in summary, it says here in bold, as a transitional measure to provide additional flexibility, where you identify that an EEA citizen in your workforce has not applied by the 30th of June, you do not need to cease employment at the time you identify them without status. You should advise the individual to make an application within 28 days. They have to provide you with confirmation that they've made the application, which can be the certificate of application or the email. And once you have that, you have to request the right to work check from the Home Office employer checking service. The key thing here, though, is that the employer might choose to cease employment as well. And this is where your only options are basically to negotiate. Now, if you haven't applied at all and you're looking to find work, then you don't have a right to work. So please apply as soon as possible. Now, in the final minute, I just chose two problems and solutions for you. The very frequent problem we hear about is that employers ask for a share code and you don't have it. This generally happens because of the backlog. And our recommended solution is to do it softly, to explain to your employer that there are more ways to check an applicant's right to work than just through the share code. The share code is just one of them. You can cite the Home Office Guide to Employers that I've shown you right here, or you can contact an advisor for help and they'll show you how to do it. Now, in the second scenario, it's basically what happens if the communication fails and your employer actually mistreats you because you don't have a share code. We've seen a lot of misunderstanding at the employer's level about the right to work check process, and the fear that the Home Office will penalize them for hiring people without status. We've seen them take all kinds of wrongful action, including unfair dismissals or asking people for unpaid leave, or even refusing to hire certain job applicants. That's wrong. And our recommended solution in this case is to remember that you have rights. Remember that table. Even if you're pending, you still have those rights. And as long as you have the right to work because you have made an application, your employment rights are protected, okay? Including protection from unfair dismissal or discrimination. You might want to start by explaining that to the employer. And our recommendation is to always try to speak first, do it softly, don't just jump to threats. If this fails, speak to your union rep or an employment advisor, and you could have grounds to take action. And with that, I'm going to thank you for following my 20 minutes and hand over to the wonderful Henry.
But just before, Olivia, just one comment that we received. There was one slide where it said December 2021. I think it was meant to say December 2020.
2020, that's right. Yes, typo.
Yeah. But yeah, so thank you very much, Olivia. I think that a lot of people will have a little bit more clarity now. And my colleague Jay has shared some links to get to Work Rights Center, so that if you have like any more issues, more direct situations, you can contact them. But also now we're going to hear from Henry, who will be able to tell us more about just what Olivia just said. Like if you get to that situation where you do feel that you were discriminated against, or that relationship really breaks down, who can you count on? And that is often what unions do. So Henry, actually I'm sharing my screen for you. So just say next when you want me to.
Hi, yes, thank you very much, Lara, for this. And yeah, going after what Olivia just has spoken about, having a representative or talking to your representative. My name is Henry Lopez. I'm the General Secretary of the Independent Workers Union of Great Britain. And I'm here today to talk about trade unions, but also what trade unions are for. So the talk that I'm gonna give you today is what is trade union and why you should join one. The second is workers' rights and contracts of employment. The third is organizing for collective power, and the fourth, getting involved in order to create real change in the workplace. Now, I think we have all been through issues in the workplace in different kind of ways. If some people haven't been, well, that's that they've been lucky, especially in this country. If you work in precarious employment, you are certainly to have problems at work, where you might find yourself in a very difficult situation, as unfortunately the law in this country is not on the side of workers, but also the system is not on the side of workers either, because there's no institutions or even government institutions that are there to help you when you have a problem at work, and it's very difficult for you to get justice through the system, because either you have to take the employer to employment tribunal, which will cost you thousands of pounds, which makes it even difficult to do that. So we're going to talk about the importance of being a member of the union. And as you can see in the picture, there is something about unions and there is something about sindicato. Sindicato is in Spanish means a union as well. And that's what the picture shows, that there is a diverse membership in unions, people from all backgrounds, all languages, different nationalities coming together into one body in order to organize themselves. Can we go next slide, please? Thank you. So why is a trade union and why should you join one? As you can see in the picture, all of those people are members of a union, members of the IWGB union, who have organized collectively despite working in different sectors. Some of them work as cleaners, some of them as security guards, some of them as porters, some of them work for the central administration or a university where these workers have been organizing in order to improve their conditions at work. Many of them have different issues. Some of them might not even have issues, but the idea of being in a union is that you don't wait to have a problem in order to get support, because unfortunately, if you are not a member of a union, before you have a problem, the union won't be able to help you with your problems. In this country, there is hundreds of trade unions, which you can join according to the sector you work. In the IWGB, for instance, we represent workers from the cleaning industry, security guards, people who work for couriers, people who work for private health drivers, who work for Uber, and all these platforms. We have people in universities, and we have workers in the charity sector, in the game workers industry, yoga teachers, and so on. So a trade union, as you say, as we can see here, is a group of people working together to improve the conditions in their workplace. As it says here, employers normally have a lot of power, and it's difficult for one worker to challenge your employer, even when they are doing something illegal or something that is going against your workers' rights. It's very difficult for you to challenge your employer on your own. And the only way to challenge your employer, especially if you work in a place where there's many workers, is by organizing collectively, but also by being involved in the union, because the union will provide you the knowledge and also the information that you need, but we also represent you if you are in a difficult situation. So by joining the union, you will be part of a set of workers who are part of your workplace, who will come together and discuss the issues that you have in collectively. And there are things that you can change in the workplace by unionizing the workplace collectively, which is easier than fighting on your own. So the more power you have as workers, the more easy it will become for you to solve the problems in your workplace. That's what's important to organize in a workplace and to join a union. Normally, unions rely on the support of an active participation of its members in order to be successful. The unions can be the best, can have the best activists, but if the workers are not engaged or are not involved in the union, it's very hard to help you to improve your conditions at work in whatever situation that you are. Maybe you are a low-paid worker, you want better wages, or you have bad conditions in terms of sick pay, holidays, or other things that you might be lacking in the workplace, or other workers might have better conditions than you, and you will have less conditions, which is a thing that happens in many workplaces with outsourced workers and workers who work directly for the institution. And as I said before, it would be very expensive if you take a case on your own. And obviously, not everybody wants to take a lead in the union, especially at the beginning. Everybody's scared about joining a union sometimes because they think they're going to get in trouble. But in many of the cases we have seen, is the other way around. Normally, you get in trouble when you're not in a union. Once you are in a union and you have a representatives and you're talking to a union, you are involved in the union, you will have more power, but the employees will respect you because they know you are protected by an organization that will be backing you up whenever you have problems in your workplace. And that's what trade unions are all about. So that's important if organizing your workplace, talking to your colleagues, talking about joining a union, because as I said, it's very difficult in this country to get justice if you are in trouble. So join a union before you have any problems, because if you have a problem, it will be very difficult for the union to support you. Many of the unions don't help when you have problems, because if we only had the vote to the union when we have problems, then the union wouldn't exist, and it will cost a lot of money. If especially in this country, it's very, very expensive. And we got the next system. So this is some of the workers' rights and some of the that normally employees have in this country. So these are the many rights that you have as an employee. So if you work, there is many different contracts in this country. Some of them for employees, some of them are called for self-employed. The other ones are for workers who work in the gig economy, for instance. And there is also contracts like 0 hours contracts. So if you are an employee and you have a contract of employment, all these conditions apply to you. As it says here, you have, for instance, the right to have a contract of employment, not to be discriminated at work, the right to be accompanied by a trade union representative. For example, if you have a disciplinary in your workplace, sometimes you do things that you might get in trouble, but you have the right to be represented by someone from the union. In our union, normally we take even translators when you don't speak the language, for instance. And you also have the right to appeal. And then if the case is not successful, then you have the right to go to court and to take the employee to court. And that's the work that the union will do on your behalf once you are a member. You also have, right not to be discriminated. There is many laws in this country in regards to equality. There is the Equality Act 2010, for instance, which protects you, in terms of your sex, your nationality, your language. So you have the right not to be discriminated in your workplace. In many cases, this happens in many workplaces, but because you are no member of a union or you don't know your rights, it's very difficult for you to get justice when these problems arise in the workplace. So as it says here, you have the right to have a pay slip to be paid every month if you are paid every month, to be paid at least the minimum wage, to get holiday, to get sick pay, to get pensions, and to take regular breaks, to work a minimum amount of hours, to work reasonable, to have reasonable time off if you require, if you have children, for instance, to request flexible working, to take a maternity pay, paternity pay, maternity leave. So there is all these things that you have, and there are many, many other rights that you have as an employee in this country, which are not over there. They are not all here. This is just an example. But there is other contracts that you might have. This is for employees who have a contract of employment. For instance, if you have 20 hours of employment, you will have this contract. You work a set number of hours, you will have a contract as an employee. But you can also have 0 hours contract, which is a contract that is very precarious, and it's something that we as a union are against, because it means that you only are entitled to a minimum set of hours that the employee can call you any day they want. And but apart from that, you have rights as like minimum wage and all the rights that you have seen here in terms of sick pay, holiday, pensions, maternity pay, paternity pay. You have all those rights. There are also contracts for self-employment, and there is other contract for workers who work, for example, in the gig economy, such as workers who work for Uber, Deliveroo, and these companies that use the technology to employ workers. We have seen many cases where workers are terminated with a click of a button, and there is no right to appeal. There is no right. They basically have no rights. And recently, we've been challenging these platforms in the courts, and we have managed to get some rights for workers, but still these workers don't have many rights. That's why these workers have been campaigning in the streets, in the courts, in order to improve their conditions. Can we go to the next? Next, please. Thank you. So, as I said, organizing collectively. Why is important of collective power? As I said before, the union is a group of collective people who work in the same location. Sometimes you don't work in the same location, but they choose to organize in order to improve their conditions in the workplace. There's different kind of actions that you can take in order to improve the conditions, such as grievances, collective grievance, where all of you get together and talk about the issues that you have, and you can raise this against your employer. If things doesn't work, then you can resort to public campaigns. You can resort to strikes and change in order to change and improve the conditions that you have in your workplace. In our union, we have done this in many workplaces. We have improved pay. We have improved things like sick pay, holiday pensions. We have ended outsourcing by campaigning, by organizing all the workers. So all the workers have been organized together, and we've been able to do that. Without being in the union, it wouldn't have been possible for all of us to do that. Many of the times, the law, as I said, is not on our side. We cannot change. The government is not going to change pay from one day to another for us. They're not going to improve things in terms of sick pay, holiday pensions, but we can do it if we act collectively, if we organize in a workplace. Then we can do a lot of things. And in our union, especially, we have managed to do this in many workplaces, and the workers now are in a much better position where they have not just better conditions, but they have dignity and respect in the workplace. So when workers are basically get together, it's very easy to win and to make demands. But if you're not organized, it's very difficult to do that. And that's why it's important that the workers should get united. As I said before, like some people are scared to join a union, but you shouldn't be scared to join a union, because in this country, you are protected by law. The companies, employers cannot discriminate you because or victimize you because you are a member of a trade union. You don't have to tell your employer you are in a trade union. They will find out if you have a problem, and you ask the union to represent you on your behalf, which we do on daily basis for our members. So you have the right to protest, to demonstrate outside your workplace or anywhere you want to demonstrate, in order to make your voices heard. Obviously, if you are launching a campaign or if you want to, organize as a collective. We go to the next question. So getting involved in order to create real change in the workplace. What we normally do in many workplaces, as you can see in the pictures, those are workers who have decided to organize in a union in order to improve the condition. And that's why we have not just win conditions, but also stop job cuts, stop the abuses that are going on in the workplace in terms of people not being allowed. For instance, we found cases where people not being allowed to eat in the canteen, where everybody eats just because they are migrants. We found cases where people are sacked and dismissed at any time without any process whatsoever. We have people who have gone very difficult situations when they've been sick and they've been victimized by the employer instead of helping them. So this is something that we do as a union, and that's why organizing is very important. And there are some steps here that we normally do in terms of organizing, which is basically once you organize, you get the members involved, you tell your colleagues to join the union, and then you can make a set of demands once you have that collective power. Then you can also, if the bosses don't want to hear you or don't want to listen to you, you can start a campaign. You can escalate the campaign if they still don't hear you, and you can keep the pressure. You can turn up the heat by going, for instance, doing petitions, doing protests, and going on strike. In this country, to go on strike is completely legal. You have to go through a process which the union will help you. But this is something that many workers do in this country. When you see the underground that has been stopped, it's because the companies normally want to reduce the pay, or they want to cut the conditions of employment for workers. And this happens in many workplaces. And one of the last things I would like to say is that nowadays, especially because of Brexit, because of COVID, there is no better time to join a trade union. It's very, very important that you join a trade union, no matter where you are, no matter which union you want to join. But it's very important that you join a union so you are protected, but you also can get the support that you need in order to improve your conditions, but also to be represented in the workplace. Thank you very much.
Thank you so much, Henry. Yeah, there's so many things there that I wish I knew when I started working in the UK. I started working in the UK as a cleaner, and I experienced some things that at that point I really wish I had at least support and people that I could speak about the issues that I was facing. So I hope that others also take this from this presentation and consider what steps they can make to receive that protection as well. So let me have a quick look at the questions that came in when I was sharing my screen. There was one question that, yes, Olivia, do you have to get a new share code every time that you change employer, or do you just share a share code to one employer only?
That's an excellent question and simple to ask. The share code expires every 30 days, I think. So if 30 days pass from the moment you've issued the first one, then yes, you'll have to issue a new one.
Okay, thank you. Just find another one. There's a question for you, Henry, I think. It says, what about platform workers? Don't know if you understand that. I'm not quite sure I get it, Ellen. Maybe you can expand on that.
I'm not sure if talking about platforms like Uber, Deliveroo, and other platforms that use technology, and that would be good to
yeah. Oh, okay. I've got the full question. I'm thinking of supposedly freelance translators and interpreters who are now working via platforms. I guess like online services. Those who happen to be online and offer the lowest rates to get jobs. Interpreters working via hubs can be in a particularly vulnerable position. Those who work from home instead of being at the meeting, bear all of the responsibility and costs for quality of the product, need to invest heavily on their equipment, no control over length of time. Yeah.
Well, yeah, I mean, that's one of the reasons, especially, I mean, technology is changing the way we work, and this is affecting basically the whole economy in terms of, you know, workers being left without conditions, without good conditions of employment, without workers' rights, that we can see in the cases of platforms like Deliveroo, Uber. I was saying earlier that that this platform just dismiss workers with a click of the button without even you know, giving them the opportunity to have an investigation, or if they have done something wrong, you know, to give them a fair hearing. This is not what's happening at the moment, and that's why our unions have been fighting to improve these conditions for these workers and to get them more protections, because at the moment many jobs are using platforms like cleaning companies are using platforms like, for instance, cleaners. Then they make them log in, log out. Some of them don't know how to use these platforms, and they end up not being paid their wages. In this case, it's kind of the same, and that's why it's important that workers should unionize. They should talk among themselves and try to join a union so they can organize collectively. Doesn't matter if they don't work in a workplace. Even if they work for the same company, they can organize. As we have seen with people like Uber. They are all over the place, like couriers. They are all over the place. But through the union, they have organized, and we have made demands in order to improve the conditions. And I think that's something that I would suggest them to do as well.
Thank you. And I think one for you, Olivia. Are these rights set in law, or is there a risk that they will change? For example, we will have to pay for access to the NHS.
I was actually just looking this up now. They are set in the withdrawal agreement, and in theory, yes, the UK could pull out of the withdrawal agreement, but in practice, that's extremely difficult. So I wouldn't be too worried about that element.
Yeah, and Alexandra, if others are interested, in the answered section of the Q&A, Alexandra also posted the link to the EU immigration rules, and this is all set out. And for you, Henry, if someone has more than one job, they work for two employers, do they have to be a member of two unions?
No, I mean, we represent the workers, for instance, in the cleaning industry, who got like 3 jobs. They work for 3 different employers. They don't need to be members of different unions. They can just be a member of a union, so we can represent them. Yeah, I guess also depend where they work or which industries. Because some unions, for instance, there are some unions that represent only public sector. So if they work, for instance, in a university, they could only be represented there. And if they work in a private sector for another employer, they might need another union, but that's very rare. But yeah, normally in our union, we represent workers who got 3 or 4 jobs. Like sometimes, like cleaners, they work 1 hour, 2 hours for one company, but they work for different employers, so they can be a member of a union.
Cool. And another one for you, Henry. Does the right to request flexible working apply to work from home some days of the week?
I guess depend on the situation, because it might be a case that you have children and you need to work from home. You have to talk to your employer. Obviously, the decision of the employer, but it's also something that you have to raise with your employer in order to demand. But yeah, I would say I think it needs to be asked to your employer.
Also, if I can add one thing to this, is everyone has a right to request flexible working, and it may be because you want to save travel costs, or you want to spend more time on domestic chores and so on. And the employer has to follow due process and seriously consider that request. But you don't have an automatic right to have your request, and particularly exactly how you wanted it applied in practice. The employer could say, due to business reasons, we cannot accommodate this. We might be able to do something else. And this is where things get tricky. What means business reasons effectively? If you work in the hospitality industry and you are a chef and you suddenly want to work from home, I think the employer could reasonably say, we can't accommodate that. But if you're actually asking to work from home because you're a parent, and you could argue meaningfully that it won't change the quality and the output of your work, then the employer really should have no grounds to say no.
I would also say that that's important of being a member of a union, because sometimes it might be a case that it turns into a discriminatory case. Like sometimes you have to look at a case as well where the work and where the worker, who he works for, who she works for, because it might be that they are giving the opportunity to other workers, but they are not giving opportunity to her. So it has to be case by case. You cannot say that every case is the same. It depends.
Thank you. So now I've got 2 more questions, one for each. One is from Martha Westlake, and I think it's more for Olivia. Hello, are there any differences in employment rights between settled and pre-settled status? In my company, some new people were offered temporary contracts instead of permanent contracts simply because of their pre-settled status. A lot of noise was made, and the company has gone back on its decision and offered permanent contracts. Was this legal?
I can see Henry shaking his head there. It wasn't right. No, that was clearly discrimination on the basis of nationality. And it's right that employees fought back and the company changed its decision. A decision about a position being permanent or temporary shouldn't be about the immigration status. As long as you have a right to work, you have a right to work. And it's your right then as an employee to extend and apply for settled status or quit or whatever. The employer's judgment about whether a contract is temporary or permanent should be about the sense it makes to business, right? So if it's an important position that they would see themselves having for the foreseeable future, then there's no real reason to make it a temporary contract. So well done for fighting back.
Yeah, I would say I will go back to where I said before. There is no better time to join a union now because of Brexit and because of the pandemic. This pandemic has brought up all the problems that these countries have in terms of the exploitation and in terms of the lack of law enforcement that there is in this country. many of the employers do exactly what we're talking about here in regards of discriminating workers because of their worker status. I mean, if they have the right to work in this country, they shouldn't be discriminated in that way. But it's happening everywhere because workers are not organized or they are not protected.
Well, I think let's try to unpack a little bit more, because Olivia touched on this as well. How can you make that understanding of when it's reasonable and unreasonable for an employer to be asking you to be, for example, permanent or temporary, or for you to make sure that you're not being discriminated against under reasonable or unreasonable grounds? How can you make sure of that?
If I can answer this, there are best practices for employers and policies, and they shouldn't. Hopefully, if they're a good employer, they don't have to be very wealthy or have a massive HR department. They should know that whether you make a contract permanent or temporary really depends on how you see that position. Is it critical to the organization, or is it purely based to a project that will have a fixed end and will not continue, and you have no intention? This is really about the intention that will not continue. I think there's a real danger here that risk-averse employers think, well, we don't know what the market's going to be like next year, and we may or may not have funding for this position, but fundamentally, no one has infinite money that's secured forever. So it's really about governance. It's about a decision and the desire that the employer has about that particular position. And if the desire is to continue to have it for the foreseeable future and to strive to maintain it, then the contract should be permanent. If they know for a fact that it's just a little project and they have no intention, like you're redeveloping your website, you're not going to do it forever, right? You're just going to do it for a short amount of time, then it makes sense to have it temporary.
Henry, do you have anything to add?
Yeah, I would say that, I mean, many of the cases we have found is that employers do that, and it's very difficult if the workers don't know their rights and don't have any way of demanding better. But I think many companies can put like different contract of employment depending of some of them give less conditions even to some of the workers and more conditions to some of the workers. So depend of the company that is doing that as well. I think in the law, every worker should be treated the same. They should all have the same contract of employment, but obviously companies get away with it. We have seen cases when I used to work at University of London. We won conditions for like better sick pay, better holiday, better pensions, and London living wage in my workplace. And people who were coming new, they were not giving them those rights. They were only giving them basic conditions. So what we did, we raised a collective grievance from the union and said, no, this is wrong. You need to stop. And they suddenly changed it. And they gave all the conditions to the newcomers as well.
Yeah, I think we've touched on a really important topic, because I can see that since we started talking about this, more questions have come in about this exact topic. So can employers insist that they will only employ people with certain types of immigration status over others? Or can they, for example, disadvantage you compared to a British citizen? Maybe just emphasize again.
No, they cannot. They cannot. The only thing they can ask for is that you have a right to work in the UK. Unless it's a government position that requires a particular type of security clearance, and that would be a very niche, extraordinary scenario. If it's just an ordinary job, they will have to ask that they see your ID and proof of right to work in the UK. And if you have settled or pre-settled status, you have that right. Even if your application is pending, you still have that right.
Yeah, that would be completely discriminatory if they are doing that, because they have different status in terms of employment, but also in terms of visas or anything they have. As long as they can work, they have all the rights, same as everybody else.
Yeah, thank you. Okay, then we have got one from Monica. I have worked as a carer for 8 months. It strikes me that all carers have to use their own cars and their own phones to do their jobs. Would you agree that under Health and Safety at Work Act, which says that employers have responsibilities to provide equipment necessary for the employee to do their job, it is not possible for the carers to provide domiciliary care without cars or phones? I'm thinking, would like to organize a petition asking for this. All care companies to provide cars and phones. Can a union help with that? And sorry, that word is really difficult.
Yeah, I think it definitely, obviously, that's important of organizing, because as I said, many employers, they just put the rules, and in some cases they make workers bring their own equipment, or in this case, like bring their own cars in order to do their jobs. I think if that person would come to the union with a problem, I think it would be difficult to help, but I think they need to organize collectively in a union in order to improve that, and also to make a collective grievance, for instance, against the employer if it's not something acceptable, and then to take it from there in regards to escalating. But they should definitely try to organize their workers in the workplace in order to improve those conditions.
Mm-hmm. And then there's a very specific legal one here for Olivia again. I just lost it. I just wanted to ask if, as an EU citizen with indefinite leave to remain, the old UK system of stamp on my passport, can an employer accept this?
If you have it, then yes. This is really interesting. I remember sitting into seminars with immigration solicitors, and that's exactly what they said as well. If you have indefinite leave to remain, then that proves your right to work. So your employer shouldn't insist on getting a different right to work. But at the same time, within the same seminar, the immigration solicitor said, if you want to make your life easier and not have to have these conversations again, then you might as well apply for the EUSS as well. So that's the answer. In theory, no. If you're willing to have these conversations, you have a right to work already. In practice, if you'd rather not have the conversation, then apply for the EUSS.
Okay, thank you. I think I'm going to take a couple more only, but then if there are more, people can keep in touch with us. So just one from Ellen. Once a potential employer has obtained your photo via the share code procedure and then decides not to employ you, can you ask him to remove your photo from his database? And if you do work for that employer, how can you make sure that your photo has been removed from his records after the statutory 30 days?
Yeah, if you don't work for them, then they don't need to keep these records by law. They might have some internal policy, but I'm sure that if they're good employers, part of those policies, they include data destruction, right? And you have a right to make a subject access request and say, I'd like to know what data you have on me. Obviously, you know that they'll have that printout of your right to work check, and you can say, please delete it. So yeah, you do have that right, as everyone in the UK. Subject access request is called.
Cool, thank you. And then another one, having settled status, are there any issues working for a British company remotely from an EU country? It seems feasible from the personal income tax point of view. What about any impact on settled status and potential corporate tax for the company?
This is complex. So, and I'm looking to the 3 million as well to chip in if I get anything wrong.
I can't help.
It depends on your status, right? If you have pre-settled status, you can technically be out of the UK for 2 years. If you have settled status, you can be out of the UK for 5 years before you lose those statuses. One thing to really be mindful of is that if you only have pre-settled status and you have an intention to continue to live and work in the UK and you want to apply for settled status later, then you have to accumulate what's called a continuous period of 5 years of residence. And continuity effectively means not being out of the UK for more than 6 months in any 12-month period. Now, the truth is that I don't know if working for a British company would actually meet the residence requirement, even if you were, out of the UK physically? I think that's a question for an immigration solicitor as well. I would welcome that question via email and encourage you to submit it.
Yeah, Luke, I know you're watching from somewhere. If you have anything they want to comment on, but I guess Olivia is right that some questions are very specific about your situation, so you may need direct legal advice. And then there's one final question that I don't know where it is anymore, but I kind of remember that it said that, of course, the number of applications for the EU settlement scheme were over 6 million compared to initial estimates of 3 million. Wouldn't it make sense for us to be better represented in politics? And to that, firstly, the 3 million is non-party political, so we wouldn't be encouraging one party over another to stand for EU citizens' rights. But what we do is a campaign for all parties to represent our rights and our issues. Before the May elections, we had a pledge where local councillors could sign up to saying that they would, if elected, continue to fight for EU citizens' rights, campaign for things like physical proof of status and for EU citizens' voting rights. And now I'll ask Alexandra to post a link here. The Young Europeans Network are working on a campaign for residence-based voting rights, because we believe that all residents, no matter where they were born, should have the right to vote, at least in local elections, where the effects of policies are so directly seen, such as you spend your council tax on public transport, on schools, on roads. Surely we should all have an equal say on that. So we're working on that campaign, and I invite all of you to support us. Have a look on our landing page where there's more information about our campaign. And with that, I will ask Olivia and Henry to say their final comments. We have posted links towards your Twitter page and your website so people can find out more about you, but maybe you can just say a few final words summarizing what you've just said.
Thank you, Laura. This was great. Thank you for listening. I always really appreciate delivering this. If there's two key messages I really want you to remember is, please, if you're one of those people waiting on status, don't let anyone tell you that you don't have a right to work or to rent. Please fight back and take the time to look at the process, speak to someone at the Work Rights Centre or the IWGB, but you have that right, so hold on to it. And the second message, I guess, is, don't be alone. If you're struggling with anything, write to us, write to Henry, and tell us what your problems are. And also do follow us on social media. We really try to work hard to anticipate people's questions, produce easy visual guides, and we update this on Twitter and Facebook every day. So do follow us at the Work Rights. Thanks, folks.
Thank you. And just before Henry starts commenting, I will just, before I forget, I will launch a poll on what's the next topic that you would like to see covered in this Life in the UK series. So I'll launch the poll now, start voting, and I'll let Henry start talking to us about his final words as you vote. Henry?
Sorry, can you say again?
Just final comments, final summary of everything.
Okay, yeah, I just want to say basically, you should definitely follow us on social media, find out about the campaigns that the IWGB is doing at the moment, and also get involved in our campaigns. If you are already a member of a union, do support us in our campaigns, because we are trying to change the system in this country in terms of workers' rights, to improve the conditions in workplaces for workers. And I really encourage you once again to join a union, to be part of a change, because if we don't take part on this, as I said before, the government is not going to change this for us. Is it us who need to create this change? And that that's something that we have showed with many examples in many workplaces, winning the London living wage, winning better conditions, ending outsourcing, getting rights for workers where they didn't have before. So a change is definitely possible if we all get together and organize. So thank you.
Thank you. And the result of the poll is, well, can you see it? Yeah, pensions in the UK. I guess I had predicted this because some questions came through in this webinar's questions. So yeah, keep an eye out for on our social media and our newsletter, and we will organize that next time. Thank you very much for Henry and Olivia for coming here today and talking to us about all of this. It's very, very helpful, and I think I hope they've all learned something, and keep in touch. And visit the websites that have been posted today here so that you can learn more. And I will send an email to all of the attendees as well with other key things that you may need to want to know about.